they kept going up on this issue and whether or not the person was credible. And the Ninth Circuit said, well, we're not clear if it was a vehicle. Maybe it was like a truck or something. But I think anybody who knows Chinese can recognize the problem here. The translation was the issue because in Chinese there's no distinction between singular and plural, right? So it seems self-evident that the person was not saying 12 or 13 people came in a car. He was saying they came in cars. It was that simple. But the translator initially translated it as car, never fixed the translation, and it went all the way to the Ninth Circuit itself, with apparently nobody recognizing the problem. And when you think about this, our complaints about sophistication in China, they kind of come back a little bit on ourselves, doesn't it?
Over here on the far right.
Hi, thank you very much. John Hahn from Cobra. I just had a question about the litigation arbitrage point that you made. I wonder if specifically that is referring to the breadth of the U.S. legal discovery rules as compared to the Chinese ones. And for companies that are making a deliberate choice to either conduct simultaneous proceedings or to sequence one after the other, what has been your experience about how receptive Chinese courts are to taking discovery in the U.S. that would not generally be available in China, either by a U.S. company or maybe have there been Chinese companies who are resorting to a U.S. forum to take advantage of those laws as well?
Well, it's a very complicated topic, and I'll try to give you a brief answer. I'm working on a paper actually on this topic, so I've got a lot to say, and I'll try to keep it short. What I see happening frequently is, it's just like in economic arbitrage. When you have two levels that are distinct from each other, you can play off the difference to have an advantage for yourself. And so the easiest example is the one that you mentioned, it's discovery differences. In the US, we have very broad discovery compared to almost anywhere in the world. And China, as well as some other countries, has much more restricted discovery. Just to take a couple examples, there's a lot of concern about state secrets in China. Or we work with banks, there's secrecy laws. There's all kinds of issues about discovery. They don't have, as Mark mentioned, a very robust discovery system in general. And so you can play off that difference. And if you say to the judge, well, I don't think the Hague Convention works, Your Honor. It takes a long time. We haven't seen it work very often. There's only maybe one or two cases where people actually followed this. Can't you just order them to turn it over? And then if you're able to convince the judge to do that in the U.S., then you have a court order requiring them to turn over documents that violate Chinese law. And now here's your situation where you have a great opportunity for litigation arbitrage. I'll just mention, without naming names, there's a top 25 vault law firm that has a webinar up on its homepage talking about if you are interested in trademark or copyright litigation, how can you make money from it when the defendants often don't have any money? And they suggest using this method. They don't say it directly, obviously, that would be a little bit extreme, but they basically